atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy.
I'm Travis Taylor, a political scientist by training with my doctorate from the University of Kentucky and a public opinion researcher by day. I'm joined on today's episode by Joshua Douglas, the author of The Court versus the Voters, the troubling story of how the Supreme Court has undermined voting rights, which was released on May 14th. In fact, it reached the number one spot in its category on Amazon during its pre-order period, so a lot of people are excited to read this book, and for good reason. Professor Douglas is the Ashland Inc. Sears Distinguished Research Professor of Law, that's a mouthful, at the University of Kentucky's Rosenberg College of Law. He teaches and researches election law and voting rights, civil procedure, constitutional law, and judicial decision-making. He's published numerous law review articles in some of the country's top journals and is a frequent media contributor on election law. Before joining the faculty at UK, Professor Douglas clerked in the Fifth Circuit Court of Appeals and was a private practice attorney after earning his law degree from the George Washington University Law School in Washington, D.C. I could have told you a lot more about Professor Douglas and his impressive career, but we've only got a short period of time with him today, so I had to cut it short. Welcome, Professor Douglas, to the podcast.
Thank you so much. It's great to come on.
Yeah, great. Glad to have you. Look, most of us in political science, we're election nerds in some way or another. It's why we got into political science in the first place. Tell us a little bit, or you talk about this a little bit in the book, but tell the listeners how you came to be interested in election law.
Sure. So I was a political science undergrad major in Washington, D.C. I went to George Washington University for undergrad as well. And just because I had always sort of remember as a kid going with my mom to vote and recognizing the power of engagement in democracy. So I went to college, majored in political science, and was in D.C., during the 2000 presidential election, witnessed Bush v. Gore while there. And then a few years later, I went to law school, and in my second year took a voting rights course from Professor Spencer Overton. And my eyes sort of opened up to how my law training that I was gaining then meshed with the political science background that I had. And so kind of combining the two interests is exactly what that course was all about. And that put me on the path to what I do today.
That sounds great. You mentioned going to vote with your mom. It sounds like you are a much more analytical kid about elections than my boys are. They just go for the stickers.
Yeah, I don't know. I mean, I have vivid memories of going with her and, with the old lever machines where the curtain would close behind you. And I remember talking about, what was on the ballot. Maybe it helped that when I was in, maybe third grade, fourth grade was when Michael Dukakis ran for president for Massachusetts, and I was living in Massachusetts. So, I think people in the state were particularly interested in that election just because it was the home state's governor running for president. And, I remember having a mock election in elementary school as well. So I do think that, instilling these values, talking to kids about them, but even, exciting them by getting the I voted sticker and taking a picture. I do this with my kids. We take a picture outside the polls every time, and we always go vote as a family when we can. It's really important for sustaining a future generation of engaged citizens.
Yeah, that's very well said. And I'm going to have to take your lead on taking a picture. I honestly never even thought about that. As long as we do it outside, I guess. A lot of states, I think, restrict that inside the polling place. Is that right?
Yeah, look, Kentucky, it's generally fine. Kentucky, you can take a picture of your ballot, so-called ballot selfies. We usually take it near the vote here sign. And it's kind of funny, I've written some about lowering the voting age to 16 for local and school board elections as a kind of mechanism to engage younger people. There's a lot of countries that have lowered the voting age to 65. Lowered the voting age to 16. But when, my kids were much younger and I took a picture at the polling place and and posted it on social media. I got a lot of funny comments back of like, you're really crazy about how low you want the voting age to be with the youngest ones at the polls.
Yeah, I think I remember you presenting some of that research in the Department of Political Science when I was there at UK.
Yeah, and I think that may have been in part from my first book that came out in 2019 called Vote for Us, How to Take Back Our Elections and Change the Future of Voting. And chapter 1 is all about lowering the voting age to 16 for local and school board elections, which has happened in a handful of places in America.
All right. Well, speaking of your books, I like that transition. So thank you for that. Let's talk about the new book. And let's start kind of simple. Tell the listeners what the book's about. What's the premise?
So I like to answer this question by answering a related but maybe slightly different question, which is why I wrote the book. And that will get into kind of the quick summary of it. So after that first book, Vote for Us, which was all about kind of positive news in voting rights, and I think it was pretty successful in terms of creating a conversation about the kinds of local grassroots movements that are available. I basically wanted to do it again. I had so much fun doing it the first time. And so I thought I'd write a book that I was tentatively calling The Great Election Compromise that would look at and explore 4 principles of voting policy that basically everyone should adhere to. And so I presented it to a trusted advisor. And she said, this is great. Why do you want to write about something, called the Grand Election Compromise? And I said, well, one of the big problems is that the Supreme Court has been so bad on voting rights in recent memory that maybe if we can get to bipartisan solutions, we can avoid the court altogether and all of its bad decisions. And she said, that's interesting. Your Grand Election Compromise is your conclusion. So that's your conclusion to the book. And I said, what do you mean? No, that's the book. And she said, no, that's the conclusion. The book is why the Supreme Court has been so terrible on voting rights. And so that's what it turned into. The book is essentially case studies. Each chapter is a deep dive into a major Supreme Court decision on the right to vote. Many people have heard of, like Citizens United or Bush v. Gore. Others, most people haven't heard of unless you study this area. But they all, in combination, contribute to a sense that the Supreme Court has underprotected the constitutional right to vote. Now, each chapter is full of stories. I love stories, and I think stories are the way to tell this narrative. And so they're woven together in a way that hopefully entertains people, but also sends the message that a series of cases, and it's not just been in the past, 10 years or so of the Roberts Court. It's really, from the past 40 or 50 years that the court has underprotected the right to vote through these various cases.
Yeah, that was one thing that I really appreciated about each chapter as I was reading it was you told in a lot of instances, not just the kind of the facts of the case itself, but the stories of other people who were perhaps involved in the litigation or folks who were impacted by it in one way or another, kind of interspersed with, it sounded like very personal interviews with some of the litigants and attorneys. And so I thought that really added a lot of kind of depth and color to what otherwise could have been a very dry casebook.
Yeah, my first book, one of the best compliments I received was that someone said, I heard there was a book by a law professor. I figured I wouldn't be able to understand it. And I found it really interesting. And I think it's kind of like a beach read. And I never thought that, my book about voting rights would be considered a summer beach read. But that's what someone who I didn't know called it. And I thought that was really flattering. And so I tried to do that again in this new book because, these issues are so important for everyone to understand. Voting is the backbone of a democracy. And so it affects all of us. So I purposefully try really hard not to just write to other law professors or to academics, but to write to the general public. And the way to do that is through stories. And so, as you said, I interviewed a lot of people. I probably conducted, 30, maybe 40 interviews as part of the research of this book. We tracked down some people that were pretty hard to find. And I say we, my research assistants who helped. But what I learned from this was a couple things. One, the richness of people's experiences and how going to the Supreme Court really impacts people. And also the power of individual voices. I mean, Supreme Court cases, we might think of them as, these, theoretical, high-minded issues, but they affect real people. And I wanted to make sure that the real people had a chance to tell their stories and the way it impacted them and people like them. Voting is very personal, and so are the disputes about voting that end up making it to the Supreme Court. And the overall message that the court has sent affects people so much as well. It ultimately has an effect on our democracy, but it's everyday voters who feel the brunt of it. And I wanted to bring out their stories.
Yeah, and I think you did a fantastic job of doing that, which this conversation that we're having about, you said you didn't necessarily write the book for other law professors. Who is the target audience for this book? Who should go out and buy this book to read it?
Well, everyone, of course.
Of course.
But certainly I think law professors would find interest in it. Certainly those who already know these cases might not know some of the various tidbits that I uncovered. I went to the Library of Congress and read the papers of the Supreme Court justices to find the needle in a haystack of interesting tidbits about them. I listened to the oral arguments of each of the cases to learn kind of what the tenor of the arguments were. So that's not to say that law professors would not be interested, but I purposely wrote this for the general public. So I think the sort of ideal audience member is the engaged, interested person who sort of has a sense that maybe things haven't been great at the Supreme Court. Maybe they've heard of the Citizens United decision about campaign finance, but doesn't really know what it says. Or maybe they've heard that the court has been harmful to the Federal Voting Rights Act, but that's all they know, basically. And maybe they know a little bit more details, and they want to learn more. They want to become a more engaged, better informed consumer of democracy. That's the person who I think would enjoy the book the most. But of course, because all of us, in my view, should be engaged voters and engaged participants in democracy, then all of us will hopefully gain something from the book.
All right. And I will say that as I read it is a very accessible read. Like I said earlier, because you're covering in depth a number of Supreme Court cases, it had the potential, and probably if it had been written by any number of other law professors or political science professors, it could have been very inaccessible, but it is very accessible. And it's clear that folks who aren't lawyers or aren't academics could read this and get a lot out of it. And so my question for you is kind of what was the purpose in writing this book? You talked about folks becoming more engaged or more informed as they read it, but what was your idea for writing this book? Was it to persuade people? Was it just for information? Was it just kind of a way to get all of this out of your head and onto paper, and op-eds just don't give you enough space to do that? Kind of what was your purpose in writing this book?
I guess I would say there was two main goals. And I already mentioned at the beginning of our conversation this idea of the grand election compromise, which was the initial impetus for writing a book. And I don't think the goals here have changed, and they're twofold. They're to inform and to hopefully spur action. So I do think that we need much better civics education overall in this country. And that's, not only in K through 12, but through adulthood as well. I think that we can do a better job as a society of helping people understand how the machinery works. And if we don't, we see, all of the misinformation that gets spread. We see people who think they know kind of how things work, and the myth becomes reality. And so part of the goal here was simply an attempt to educate. As a professor, I'm an educator. And so I don't need to only try to educate my students, but, educating the all voters and learning from them at the same time. I've gained so much knowledge as I've gone through this process. And then the second goal would be to engage people to understand that we don't have to accept the system as is, that there are ways we can meaningfully improve our democracy. And through all the threats that we're seeing to democracy that people are talking about in the past several years, the hope is that someone reading the book not only is better informed about how the Supreme Court has had a significant role in the constitutional right to vote and shaping and previously protecting and now not protecting individual voters, and as a corollary, trusting state politicians in voting laws, the very people we shouldn't really be trusting at all, but also then understanding that there's a role for them, whether that's simply making sure they're registered and going to the polls, whether it's getting their friends to register and go to the polls, whether it's joining an organization to fight for bigger and bolder changes and reforms to the Supreme Court and to voting policies. I think all of those are possible. So, the short answer here is to both inform and engage.
Okay. For those of listeners who are typically informed and engaged already, they're aware of kind of this debate going on right now in the public discourse about voting rights. It seems to me that there's this divide between people who are most concerned about stopping voter fraud and those who want to stop voter suppression. So it's kind of this fraud versus suppression debate that's going on in the public discourse. Where does your book fit into that debate?
I think in a couple different ways. So one, it helps to understand how the Supreme Court has entered that debate. Several of the cases, for example, like the chapter 3 on Crawford versus Marion County, a case about voter ID laws from 2008, kind of presents that question directly, right? The debate between access to the polls and making it harder for people to vote who don't have an ID, and this idea that a voter ID law can help to prevent fraud. So the Supreme Court has played a major role in that debate, in that conversation, and has placed the thumb on the scale of politicians to let them kind of do whatever they want and justify its voting rules by saying that is trying to root out fraud, even if there's no evidence whatsoever of fraud in the system. So I think, the people who are kind of aware of this access versus integrity debate will gain a lot of additional knowledge. I think those who don't study this area directly probably don't and probably have never heard of the first two cases that I discussed in the book, Anderson versus Celebrezzi and Burdick versus Takushi. And yet those two cases are so important for understanding the Supreme Court's approach to voting rights. And then the second big thing I think that people who understand or recognize the access versus integrity debate might gain from the book is this idea that it doesn't have to be an either or, that you can actually achieve the goals of enhanced access to the ballot box and improved security at the same time. And so when we get to the end of the book, I think that hopefully is brought out that there are definitely ways to achieve the dual goals of making sure, because I do think that integrity is an important part of the voting system, but it shouldn't come at the expense of voters.
So let's jump into the meat of the book now. You just mentioned the first two cases that you cover in the book, and previously you mentioned a third. Those are Anderson, Burdick, and Crawford. So you call them the ABC cases. But you start the book off by saying that earlier cases prior to Anderson used strict scrutiny to evaluate voter rights cases. Now, we've got a lot of listeners who are not attorneys or don't have any training in, even at the undergraduate level, in kind of pre-law or anything like that. So explain for the listeners what is strict scrutiny, how it's applied, and how the case law has gotten away from that standard in recent years.
Sure. So strict scrutiny is the highest level of judicial oversight of a state law. And we see it, it's not just in voting rights. We see it in issues of the First Amendment. free speech. You see it used in issues sometimes of rights of privacy. And basically, the test says that we're not going to just trust states to do the right thing when they pass laws. We're going to make the state justify its law. And the test basically has two parts. First, the state, to justify its law, has to show what in the law is called a compelling interest, a compelling state interest. You can think of that as just a really, really, really important and good reason for the law. And then the second part of the test is, does the law actually achieve that goal? In legal terms, it's called narrow tailoring. But again, you can just sort of think of it as kind of a means end test of, does the law actually achieve what the state is saying it's trying to achieve? So in voting rights, the cases from the 1960s, for example, there was a case called Harper involving a poll tax, where Virginia used to impose a poll tax to vote. And to justify that law, the state had the burden of showing that there's a really, really, really good reason for the law, and that the poll tax law actually achieved that purpose. So the state, may say, well, we want voters who care enough to pay a poll tax. Those are the kinds of voters we want. You might have the state say, well, we're trying to raise revenue. That's what a tax law does. And again, the second part is, okay, does the law actually achieve that goal? Does the law achieve the goal of having an informed electorate? And the court, and again, refusing to defer to the state's rationale, basically said, no, yes, it's a good enough goal to want voters who are informed, but requiring them to pay to vote doesn't achieve that goal, because you might have voters who pay the poll tax and don't pay attention at all to politics. You might have voters who are too poor to pay, but are, really engaged and informed. And so the law was struck down. So that's how it used to be. And that's where we had very strong protection for the constitutional right to vote. The state was not allowed to infringe that right and make it harder for people unless it had a really, really, really good reason and the law actually achieved those goals. But in the Anderson, Burdick, and Crawford case, as you noted, the ABC trilogy, the court begins to pull back on requiring states to justify their rules and instead begins to defer more and more to the state's rationale, the state's justification for its law.
So when you're talking about strict scrutiny, you use that phrase, compelling state interest, or for the non-attorneys, a really, really, really good reason. To some, that might sound a little squishy. And so how is it explain to the listeners how that ABC trilogy, with more deference to the states, isn't just the court saying, okay, that was a really, really, really good reason.
Well, so the difference here is that in strict scrutiny, I don't think is that squishy, because the court was basically saying, state, provide evidence to prove that you have a need for this kind of a voting law. You have an allegation and some evidence that the law is infringing upon voters' rights. Now, state, you have the obligation to actually prove evidence that you have a need for this kind of regulation. ABC trilogy, the Anderson, Burdick, and Crawford cases, is where it does become squishy, because now, under those cases, the state is no longer required to provide as much or even any evidence to demonstrate the need for its law. And to put this in more concrete terms, in Crawford, the voter ID case, the state of Indiana said, well, we are concerned about voter fraud and we want to improve election integrity. And the court said, yeah, that's fine, without requiring the state to provide any evidence that there was any fraud in the system at all, right? The state just could say, well, we're worried about it. And that was enough. Under the prior test of strict scrutiny, that wouldn't have been enough. The state would have been required to provide actual evidence of the kind of fraud that it was trying to prevent, and also evidence of how and why the law the voter ID law would actually prevent that kind of fraud. Now the state can simply say, well, we're concerned, and that's enough. And what's interesting here is that the court has required plaintiffs to provide more and more evidence of the burdens, the harm that a state voting law imposes on them. And sometimes plaintiffs have lost for when the court has said, well, you haven't proven that enough evidence of a real burden on voters. And yet the state is getting a free pass, is not having to provide any evidence, and is just basically saying, court, trust us. And the court is. And that's exactly backwards from that strict scrutiny standard. And so why is strict scrutiny better? Well, if we think of voting as the most fundamental right within our democracy, the most important right embedded within the Constitution, then we should not tolerate infringements on that right unless there's a really, really, really good reason for it. But instead, the ABC trilogy standard flips that on its head and says, voters, you've got to show tons of evidence of why the law is harming you. But state, you don't have to demonstrate at all that you have a good enough reason for the law anymore.
All right. That's an excellent explanation. So it sounds like the question then is mostly evidentiary, right? It's how much evidence is required and who's required to provide it.
Well, it's partially evidentiary. It's partially what you just said in terms of who needs to provide the evidence and how much. It's also the lens through which the court considers these issues. And that's where I get to the deference question. Should we defer to the state and trust it and say, basically whatever state you say, however general it is, we're going to credit that justification? Of course, everyone should want to root out election fraud. Everyone should want more, better election security and integrity. The question is that enough, or are we going to require the state to be more specific about what it is trying to achieve? So I think it's not only evidentiary, but also the lens through which the court's thinking about this and the level of deference that it's giving to state politicians.
All right. If you'll allow me to play devil's advocate for a moment here, just kind of piggybacking off of what you just said, that and you write at one point in the book that even one case of voter fraud is too many. And so if a state comes before the court and says, we're trying to prevent voter fraud from happening in the first place, even though it hasn't happened before, we're trying to prevent it from happening in the future. In your view, why is that not a really, really, really good reason?
It might be a really, really good reason. It might satisfy that first part of the test, but I question whether it satisfies the second part, that the law is actually going to prevent that non-existent fraud as compared to the amount of harm that it's causing voters. And so, yeah, it might be that the state can be very specific about what it's trying to achieve. And the court might even say, yeah, that is an important interest. And so you satisfy part one of the test, but you've got to also demonstrate that the law will actually achieve the goal and do so in a way that does not also harm voters. And, when you have the rights of the state to run an election as compared to the rights of voters to cast their ballots in a free and unimpaired manner, I think the rights of voters should win out every day, right? The politicians only get their legitimacy from the voters voting them into office. And so the scale should always be on the side of the individual voters as the lifeblood of a democracy.
So then in your view, and you mentioned earlier that access and preventing fraud shouldn't be mutually exclusive. So where's that middle ground? What's that ideal balance between a state's authority to set election policy and kind of the rights of the voter and the court's ability to strike down election policy?
Yeah, I'm not saying that a state should not get to enact the policies it wants if it can satisfy a stronger judicial test. I'm not looking for courts to strike down every voting law unless those laws really do harm voters. But where's the middle ground? There are policies that we could adopt that have the dual goals of expanding access and improving integrity. So here in Kentucky, we enacted 3 days of early voting. Now, I think more early voting days might be better, but 3 is where the legislature landed on. What people should recognize is that early voting is both an access measure and an integrity measure. it's obvious why it's an access measure, right? It gives 3 additional days beyond the traditional election day to vote. It's also an integrity measure because it releases the pressure on election day itself, because it spreads out the voting process to 3 additional days. So the poll workers can watch the process more carefully, right? If you have really long lines and you're trying to process lots of voters at busy precincts, then, there's no evidence there's any fraud in the system like that. But if people are concerned about having better oversight, well, that's one way to do it. Having vote by mail, expanded vote by mail, along with using best practices, such as having a tracking system on the envelope so that you can track the ballot throughout the system, is both an access measure and an integrity measure, because we can watch the ballots go through and know where all the ballots are through the system. So there are ways that we can create this compromise, and those laws shouldn't be struck down. But when the balance is out of whack, when you have a law that makes it simply harder to vote with really no state benefit on the other side, except for the state's bland assertion, generalized assertion of, we want to run our elections as we see fit. Well, I think the state should find a better way to do it, a way that does not harm voters.
All right. So I know the purpose of this book was to highlight the cases where the court ruled in favor of the state and against voters. Over that time period, what was it, 40, 50 years, somewhere right in that time frame, were there any cases that you viewed as favorably where the court did strike down an election measure that was unduly burdensome?
Well, yeah, certainly the court has not been all bad. I mean, look at the 2020 election litigation, the post-election litigation, where there were some really crazy lawsuits filed and to try to challenge the results of the 2020 election, and the court rejected all of those. So, I think it's not all bad. There's been some cases in which the court has essentially upheld the Voting Rights Act by affirming lower court decisions that struck down a bad map. I mean, you can just look at a case from, was it just last year out of Alabama, in which the court agreed with a lower court that Alabama was required to draw a second majority black district because the Voting Rights Act, Section 2, required it. So there are examples where the court has done the right thing. I mean, I'm a little concerned about just that Alabama case, even because even in agreeing to strike down the map, it added a sentence, or I think it was Justice Kavanaugh who wrote a concurrence in that case and said, well, yeah, I agree with the result in this case, but I might want to question Section 2 of the Voting Rights Act in a future case. So even when the court does kind of the right thing, it sometimes adds these nuggets that it can use later on. So it's not all bad, but I think the general tenor, if you put all of these cases together, is one where the politicians generally win out more than the voters do.
Yeah, as a pollster, I deal a lot in top lines. That's kind of the when you take all of the results and you look at the kind of the main takeaway, you got the top line, and then we deal a lot in crosstabs. How do these numbers break down among different groups? And so that was one thing that I found really interesting in your book, is that you focus not only on kind of the outcome of a case, but you find a lot of kind of devil in the details, if you will, in some of the rationale and perhaps even some of the dicta in the court's writing.
Yeah, that's right. And, it even goes back 40 years from that first case from Chapter 1, Anderson, a case from 1983. I don't think the court was trying to necessarily pull back on protection for the right to vote. And I even think the justice who wrote that, noted liberal John Paul Stevens, didn't intend to undermine the protection of the right to vote. And then the court sort of takes the test that is initially written in that case and embellishes it further. And so there's the next case, Burdick, which we talked about from 1992. The court goes further. It sort of expands upon the initial test. And in fact, Justice Stevens dissented in Burdick, which I found really interesting. He wrote the initial decision that begins to chip away at a strong protection for the right to vote. But when the other justices start taking it further, he dissents in that case. So, I don't think there was a grand project to undermine the right to vote. I think it, sort of happened incrementally, and only looking at it through a holistic lens of the past 40 or 50 years, do you sort of see what really was going on. And then, and to your point, chapter 10, after I talk about 9 different cases, chapter 10, I call the next looming case, where I try to predict essentially where is the court going to go next. And I discuss this case that came out last year called Moore versus Harper, which people know is the independent state legislature case. And without going into the weeds of what that was about, I'll say that there was a sentence or two that I think the court could use in future cases to undermine the protection of voting rights even further.
Thinking about that case, Moore v. Harper, and some of the post-2020 litigation that you mentioned a few minutes ago, do those cases, and obviously I know you take exception with some of the language in Moore, but do those cases give you any hope that maybe the court's turning a corner, or do you think they're kind of exceptions that prove the rule that you've identified?
Well, I think the court is not going to go to the extreme. And, the argument that the plaintiffs in the Moore case were making, which is essentially to say that state courts can never use their state constitutions to protect voters, was just too extreme. Similar with the Alabama Voting Rights Act case, where the plaintiffs there, or actually, I guess it was the state of Alabama there, was arguing for the court to undo decades of precedent on Section 2 of the Voting Rights Act and really change things. And it was a really extreme argument. And I think the court's not willing to do that. Similar with the 2020 post-election litigation, where Texas files a lawsuit directly at the Supreme Court against Pennsylvania, trying to get the court to stop Pennsylvania from certifying the results of the election. Those are really extreme arguments. And this court doesn't want to be extreme. It wants to be seen as incremental. And so, I think the guardrails here are when you have very outlier extreme arguments, the court's going to reject those. But I am concerned about the so-called incremental nature of this, because what you see the court doing is it plants a plants a seed in one case and then lets it blossom into a weed in another case. And in that second case, the court just says, well, we're following precedent, and points to that first case. So it tries to, I think, gain the veneer of more legitimacy by saying we're just following precedent, by adding some of this language in earlier cases that it can then use in later cases. But I do think, to directly respond to your question, the extreme arguments are not going to fly even with this court.
Okay. So the cases that you talk about, you approach them from what some might consider a kind of a leftist point of view, right? And especially taking on reforms like voter ID that are popular with voters, especially kind of right of center voters. So what would you say to the conservative voters in our conservative listeners who may not agree with your assessment of the court? Why should they read your book, and what should they take away from it?
Well, I don't think the desire to have everyone vote should be seen as a partisan issue. I sort of don't care who wins an election as long as everyone has a ability to express their viewpoints. I think elections should be won based on all voters, not on the voting rules that are enacted. And, if you think, and I think it's on both sides, right? I don't think the Democrats should be the ones that get to dictate all of the rules and to help their side win. And, they do it in gerrymandering just as much as Republicans do it with gerrymandering in their states. So, my book, I think, is for anyone who's pro-democracy, small d democracy, and that should include all of us. And so, I welcome liberals and conservatives reading the book, even if you think that, some of the decisions were correct. Hopefully you would recognize, and I actually think some of the decisions by themselves, just the pure holding on whether a particular law is constitutional or not, I think the court maybe got it right in a couple of these cases. I'm much more concerned with the overall approach. And I think that, conservatives should believe that we don't want to give all of the trust to the current elected politicians because their interest is simply to win office. I think of it this way. We're in Kentucky, so I'll use the Kentucky analogy. If Kentucky were playing Louisville in a major basketball game and the University of Louisville got to choose the referees and got to choose the rules of the game, and they chose Louisville fans to be the refs and to choose the rules of the game, no one really would think that's legitimate, except for maybe the diehard Louisville fan who doesn't actually care about fairness. And so I think anytime either side does this, it's concerning. And we should have an independent court that upholds the ideals of all voters, regardless of partisanship. So I would welcome anyone from the ideological spectrum to join me in this effort to maintain independence and nonpartisanship or bipartisanship. It's the voters that should win out, not the current politicians who get to select the rules of the game. And just because your party may be in power at some point, the overall ideal should endure because your party may not be in power in the next time around.
That's a really good point. And I think that it's important to also just engage with ideas that you may not agree with, to expand your own worldview and your understanding of the issues, and to be able to have more meaningful conversations across the aisle.
Yeah. And if nothing else, I mean, I like using the example of Citizens United because so many people have heard of the case, but I think not a lot of people truly understand what the court actually held. For example, the court didn't really hold that corporations are people in Citizens United. That concept has endured for years, and years well before Citizens United. So those who think Citizens United was a correct decision, well, one, I'd encourage you to fully understand what the court said in that case, and you might learn something interesting about what the real rule is here and why some people do find it to be concerning.
And let's just be clear that under the basketball scenario that you just presented, the Wildcats would still win.
Of course. especially under the new regime, hopefully.
So, Professor Douglas, you've identified the problem, and you started talking about this earlier on, and I want to circle back to it. And I want to wrap up with this. So we talked about the problem. Your solution is what you call the grand election compromise. What is that solution, and how does it help get the court back on track?
Well, there's really a couple different sets of solutions here I talk about in the book, and I sort of feel like I'm kind of revealing the end here if I give it all away. But I'll highlight the four principles of the grand election compromise that I think we should be our starting place for any discussions about election policy. And they are that voting should be easy for everyone who's eligible, that election integrity should be an important component of the system, that voters should be well educated, and we should do more to ensure voters are educated, and that the losers should accept defeat. And we should, encourage and demand a peaceful transition of power. I don't think any of these four principles are controversial. And if you disagree with them, I sort of question the commitment to overall democracy. Who could deny that every eligible voter should be able to cast their ballot easily? Who can deny that we should make sure there's not fraud in the system, or that voters should be educated, or that the losers should accept defeat? But there's another set of solutions as well, which goes to court reform that I talk about in the book. I'm not a fan of court packing, which you hear about a lot on the left. I think that's a bad idea. I think it's a tit for tat that, if Democrats do it now, when Republicans come in office, they'll try to expand the court further and there's no end game. But I do think there can be meaningful reforms to the Supreme Court and the way it operates that can help bring it back to an institution that we can trust, that can give it more independence. And ultimately, the goal here is to make the decisions less about who's on the court and more about the rule of law. Right now we have a 6-3 conservative majority. It's pretty much, any hot button issue we kind of know is going to be a 6-3 decision. That shouldn't be the case. It should be about what is proper rule of law and not about the identities of the justices. And so there's some reforms I suggest that can help get us at least closer to that ideal.
All right. Professor Douglas, thank you for joining me today on the Politics Guys. And thanks for the opportunity to read the book. It was great.
This has been a great conversation. I thank you so much.
Thanks for listening to this Politics Guys interview. If you're not already a supporter of the show, I hope you'll consider becoming one, because without our supporters, we wouldn't be able to do this. And when you become a supporter, you get not just that warm, fuzzy feeling, knowing that you're supporting a good cause. I like to think we're a good cause, but you also get stuff like ad-free versions of everything we put out. You get our supporter exclusive midweek show, the full length of that, not just the preview. And you also get to be part of our Discord group if you want. And there's always some interesting conversations going on there. At the $10 a month level or more, you get to actually be part of the episodes Jay and I do, if that's something you're interested in. So there's a lot of stuff is what I am saying. And I hope you'll consider checking it out. And to do that, just go to patreon.com/politicsguys. If you want to support us on Venmo, we're at Politics Guys. You can also support the show through PayPal. And all of our support links are always in the show notes, as well as at politicsguys.com/support. And as always, I want to close with a very special thank you to our wonderful executive producers, Bruce Johnson, Wilma Moreno, Daniel Toe, Ryan Beasley, and Don Oglesby.
This podcast is part of the Democracy Group,